Ah, the classic state your name moment. No courtroom drama here, just a calm start. But let's not forget, this is where the tone for the entire case is set. And notice how the defendant, Sudan, is already leaning into the formality of it all.
I am, Judge, but it's just
What is he talking about, and
Well,
what's the holdup?
I don't think there is a holdup, Judge, other than we're just waiting on the responses from the subpoenas. I show that we have subpoenaed records from Spindletop Center. Is that one?
Yes,
That we subpoenaed records from St. Elizabeth, Christus.
and we have those.
Okay, you have those. And then Family Services of Southeast Texas.
I believe we have those.
Okay, and then
Spindletop.
so all you're waiting on is Spindletop records.
Let's see. Let me verify that. So this is Christus, and then this is.
These are all entities in Beaumont. I mean, somebody can drive over there and get them if they were told, make copies, please.
I think Spindletop
Not
usually.
like we're going to Austin with that gigantic archive in the sky. And we'd have to wait forever.
So I've got Beaumont Pediatric Center, and I've got St. Elizabeth, and that appears to be.
Retry it. Retry it. This is behind. Okay.
And you have Beaumont Pediatrics.
I have Beaumont Pediatrics, and I have St. Elizabeth.
Okay, so Judge, the only thing we were waiting on is the subpoenaed records from Spindletop Center. I just got this case 2 days ago, so I don't know exactly where they're at, but I'm saying that I'll.
Got all the others.
I've got what appears to be all
That
the
should be,
others.
y'all ought to be able to get that in 48 hours.
It shouldn't be a problem, Judge. We'll take care of it.
Do it in 48 hours, please, if you can. Get it over to me. Okay?
That that would address that issue, yes, Your Honor, but he
Right.
has been confined for more than 90 days. And
Okay. That may be the way things happen in
Smooth, right? Now the stakes get higher. We got improper turn versus impeding traffic. A simple infraction could now turn into a fine. Let's see how this plays out. Can a ticket truly change someone's fate? More than just a matter of driving. It's all about strategy.
the way things are under the bond law, right? Article 17.15 of the Texas Code of Criminal Procedure is the guiding light.
in 17.1.51, the judge is what we're asking for a reduction on.
Yeah. Okay, what's the problem with y'all being ready for trial? Just those records from,
Right. Once we have that, we are ready.
why don't you get it today?
Okay. Well, I'm in trial myself on another case already.
Okay,
So.
well, get some help from somebody in this regard, because all we're talking about here, you're announcing ready, and if the defendant raises this statute and argues the state was not ready within the statutory time period, the state must then make a prima facie showing of readiness for trial.
We can do it, Judge.
Or I'm compelled to lower his bond. Okay, it sounds like all this is something y'all can almost walk over and get. So get it. And what's his bond right now?
$250,000, judge.
All right, do you want me to read out the probable cause affidavit for the record? Is that necessary?
No, Your Honor.
Okay, well, it states, according to this child, that the defendant forced her to perform on him on several occasions. And the child was 8 years of age. And the assaults continued from the ages of 8 to 14 years of age. So,
And Judge, our position on that is if the probable cause affidavit, the indictment.
Okay, here's where it gets a bit tricky. The defendant has a choice. Pay the fine for the new charge or stick with the original ticket, complete with points on the license. Big decision for anyone who's trying to avoid insurance hikes. This is the court equivalent of choosing the lesser evil.
It's going to be considered evidence of guilt, and we should be allowed to present all the affidavits we have, all the facts showing why this could not have taken place.
Go ahead, present.
Okay. Well, so
You have you have a chance to be heard, but the nature of the offense and the circumstances under which it was committed are to be considered. And everybody knows in these types of allegations, these types of cases, and keeping in mind that the grand jury has deemed that this probably happened and he probably did it by the very nature of bringing forth an indictment. These are the types of cases that this article seems to affect the most, because these are generally some of the most disturbing allegations under law.
Absolutely, Judge. So in the house that Mr. Tovar lived in had 3 bedrooms and 8 people living in the home. Someone was always awake, whether it was 2 a.m, 4 a.m, 6 p.m. All of the residents of the home, including
How many people were there?
Up to 8 at one time, Judge.
So in my house when I grew up, and people weren't awake all night long.
Wow.
Okay, I have personal experience with that. So no, the lights are not always on. No, people are not shuffling around all hours of the night, every night. Sorry, no, that doesn't happen.
It has to do also with where people are sleeping, how they have to get by various people, who all sharing rooms together. But everybody who resided there has completed an affidavit explaining why this couldn't have happened and that it didn't happen. Additionally, Judge,
Did you see the probable cause affidavit? We're going to rely on that. That's part of, I'm looking at this, that's part of the record. And it says that people were watching television. She was with her, in her stepfather's bedroom, watching a movie with him. I guess that's the defendant. The stepfather is the defendant in this case. And her mother. When her mother left the room, that left him and her, according to this, only in the room. And then he forced her head under the blanket, exposed his penis, forced her to perform. And on several other occasions, in between the hours of 4 and 6 in the morning, he enters her bedroom, gets in bed with her, and forced her sexual intercourse. These assaults continued from the ages of 8 to 14 years of age. The way this reads here, it can be accomplished without someone else seeing and being a part of it. Can I finish before you interrupt?
Yes.
Okay, go ahead.
In this particular case, the victim also had an external hymen that had to be treated until such time as she lost her virginity. That's contained within the Beaumont pediatric records. She kept a journal detailing all of the boys that she slept with, yet not listing my client as having abused her, although she did accuse another boy of having abused her in another instance, Judge, in the journal. There's a number of things that weigh against not just probable cause, but certainly conviction in this case. The only reason Mr. Tovar is here today is because of his prior.
No, it's because a grand jury indicted him. After they heard evidence to support their decision, if they followed the rules, which no one says they didn't. Anything else? What do you have to say in response to what he said?
Judge, I think that there's...
Hold up. The defendant is about to pick the impeding traffic option. No points on the license. Win-win, right? But is that really all there is to it? Is this the right move? Or will there be a hidden catch down the line? I mean, $180 is steep, but no points? That's tempting.
There's a lot of convoluted issues that they brought up. We're looking into them, but as far as we know, the complainant's still cooperative, ready to testify, and we intend to go forward.
Okay. What about this journal thing?
We've got them. We've given them in discovery. I don't agree with their interpretations of the information in that journal. And I also don't think that a child who did have consensual sex with another child would necessarily journal about how they were sexually assaulted by an adult.
Everybody's different. What else? Anything else you want to add?
I mean, she's additionally told two of her cousins that it didn't happen.
What about that?
I've had this case for 2 days. I can't tell you every single aspect of what they're bringing up because
have you seen that in the file?
No, sir, I have not.
Okay.
I'm happy to look into any of those kind of issues though.
Oh.
And then we'll get the records squared away so that
If y'all
there's
want, the decision on bond stays the same. If you want to reopen this for another bond hearing and bring forth witnesses, I'm happy to listen to it. Okay. And consider, I'm always to consider bond. And on this one, like everything else, this type of claim, we're fast tracking this. And stand by. Yeah, we want all these continuous sexual assault cases. I want them on top of dockets, on every docket. No matter what their number is, they get put as a, because of the nature of the case, and everybody, the complainants as well as the defendants' lives are in jeopardy, and of the largest jeopardy that it seems like the law has. We are going to treat those most importantly, like the law says that we should prioritize, even if they're just 300 days old. Let's get this done so everybody's lives can move on. Bonds says the same. I don't see anything right now that's convinced me that because of the most disturbing, it's a disturbing. They're all disturbing this, and that's why this legislature has the highest punishment other than the capital punishment for this kind of behavior, if found true beyond reasonable. But so he needs to get his chance to be heard and move on one way or the other.
Yes, sir.
Anything else on this?
Nothing from the
Okay, thank you. That's all. Zero 4 Charlie Price.
Good.
Is he? Okay. Mr. Reynolds is the attorney. Mr. Reynolds, once, twice, not here.
Oh, Judge, I'm sorry, Mr. Reynolds had to step down to County Court at Law number 2, but he said he'd pop back over here.
Okay, we'll wait for him to pop out. And
Correct.
on something.
Mr. Wilkins.
All right, go ahead. Let's go on Wilkerson. Mr. Wilkerson. David Tovar.
Yes, sir.
Where's he? Yeah, we got to bring him out, please. And
Just courthouse motion, a written motion, this bond, or is this just brought up oral? Because I looked for one and I could not.
Here's a copy of one.
But it's like one for this particular one, not a previous hearing, but that's what we're going.
The second motion is what we're
This was filed
in August of 23.
23.
Yes, sir.
This is, we're going on the August 23 motion.
Yes.
and this is a follow-up from what?
That's my question.
No, it's a follow-up from,
What ruling was made then
yeah.
that we're continuing?
At the time that this motion was made,
What
there have been
motion?
records that hadn't been produced to us, which is still the case with regard to the medical And I believe the statement from the court at that time was somebody could walk over and get those today. This is when you were first coming onto this case and Sonny was discussing it, and we discussed the facts.
I came on in October, 2 months before I was here.
So, and at that time,
You're asking for relief on bond, right?
yeah, sure.
All right. I don't even have any, I don't know when the matters occurred. I don't have any writing on the outside, which which bothers this court. I don't know when these decisions were made. There was a second motion in August 21st of 23 that was filed. And I guess that's what you're talking about.
Yes.
And you want to, but we had a hearing on that and I made rulings on it, correct?
No, Your Honor, we've never had a full hearing on it.
Have we had a hearing? When was the last time we had a hearing on this? Does your records show?
The last time there was a decision made on a bond, was
Talking about a hearing on the matter, whether or not a decision was made. When was the last time we had a hearing? Thank you.
my records don't indicate.
Mine don't either.
The state file doesn't indicate that
This,
there was anything. The only thing the state file indicates is the 2022, December 22.
All right, we've got a judge with a sense of humor. Did you catch that remark about hair? I mean, come on, this courtroom is suddenly a style showdown amidst all the legal proceedings. The lighter moments break the tension, but underneath, there's a whole world of legal consequences still unfolding.
I mean, I'm prepared to proceed with it as though this.
are you ready?
We can go forward.
Are you ready or not?
I'm ready. Whatever it is. I just want to make sure what we're doing. That's my,
Well,
I look forward to try to decipher where we were. Like if we're reopening a hearing that's already started, if this is just a continuous bond thing we're going to do off one motion that's filed 3 years ago, that's my question, Judge. Where are we procedurally with this?
question really I have is what prompted this hearing for today? For this matter to be placed on today? I'm really not sure. Because I don't see anything that prompts it.
It was a discussion at a previous trial setting, Judge, and the court said, well, that the court would be willing to consider some circumstances surrounding the outcry to set a hearing on it. And so that's what we.
Okay. Are you ready for that?
I want to be clear though, first of all, what prompted this hearing is that I believe it was 2 weeks ago, we were set on this vote where counsel wasn't available for medical reasons.
Correct.
But state was here for it, and the witnesses, obviously, the family was here, and then it got reset. So I want to remind us of that. I don't know what that was. We were ready then, we're ready now. But I just want to make sure it's clear.
Well, I mean, if you need to respond, do you have witnesses available today to respond?
There's not a, I mean, Judge, I don't know what that's my point of this. I'm not sure what we're here to do other than discuss 1715.
What do you intend to do?
I intend to put on the mother of the victim to discuss the fact that there was an external hymen present, that the loss of her virginity coincided with an entry in her journal. I further intend to argue the fact that the state still has to produce the records from Spindletop, and is also saying that the announcement when it was numbered was not ready, and then you said, but you're ready aside from wanting the other case to go first. That's even if the court doesn't reduce the bond today, we need to address that issue because it would be manifestly unjust for my client to remain in jail while a case that is newer with the same complaining witness was tried to the court. So I believe that my client is entitled to a bond based on the fact that the remaining medical records have not been presented to us as they were supposed to have been some time ago.
What about that?
Because that is the first I've heard of a discovery issue.
Here's what we're going to
This
do.
is what this is.
No, here's
It can
what
be
we're gonna do.
handled.
I'm going to ask you to do this, Mr. Wilkerson. Because I don't like the way it's been impromptu addressed orally, and the state's bewildered. Put this in writing so it can be. Is this bothersome for you? Put this in, articulate your needs as soon as possible. Put them in writing so we can memorialize it, so everybody can be on notice on what the hearing is. I don't know what this is either. It's just an open kind of a thing. And I know it is prompted by the Court of Appeals decision on him that was just released. So, yeah, great, let's get this. I'll be having hearings every morning before we go into the trial in the next 3 weeks. And we can put that in there. I want to see in writing what you're talking about, because I'm not following you at all. And he gets a fair notice of what is needed. Do you understand? Can you do that and get that as soon as possible? You get it, file it, I will set it within a few days. Do you understand?
Your Honor, number 6 and number 8 from the second motion address specifically what I intend to address today. Number 6 and 8 from the second motion was filed back in August.
Okay. What, are you ready for that?
Judge, I'm not, because I don't, but that's our
When can
first
you be
question.
ready?
Whenever, I mean, we will get it as quickly as we can. 2 weeks.
What is that?
2 weeks. Give us 2 weeks so I can
You got to read.
keep them. A week's fine. I'll figure what out.
They're not ready.
We're not ready to decide what we're doing.
And truly, you're telling me right now at 9:45 what the particulars are that you want to deal with in this hearing. You got to tip us off a little better than that, especially in light, they got a different prosecutor here.
Yes, Your Honor, and respectfully, it was the first time that this motion was discussed. The transition was taking place. Sonny was here. It was when Mr. Hoppower was first coming into the case, and it was it was in consideration of the second motion, and the court said set a hearing on it. So ultimately, that is what we did, and be absent for medical reasons. The state was ready to proceed based on this motion, but today the state's not ready to proceed based on this motion. So I feel like the motion clearly articulates what I'm here to present.
If I can respond to it.
Yeah.
Let me be clear. The state was ready, but to ask the questions I'm asking today, what exactly are we?
Y'all need to, here's what I would suggest. Since I've practiced law a lot longer than both of you,
Yes.
I've never been in a situation where people are not communicating with each other and filling in the blanks. Either side is not clairvoyant. Y'all got to give each other, in all professional courtesies, a heads up of what the plan is. Not, it's going to be a bond here. Okay. I say, okay, fine. But that's a global statement. It's not fair to either side what the parameters, or we could be here for months, years. And I don't like that in light of this, my trial docket, my overall docket, and often lately, that's what's happening. People are coming in and surprising each other. I never grew up with that in the practice of law. It was always people knew heads up what the plan was. They talked to each other about, this is what we're going to be doing. What do you have for me, so that we don't waste everybody's time when we get here like we're doing. And there's not the professional congeniality that I'm used to. Y'all need to communicate. You're in the business of communicating. And I don't like hearing, I'm not sure what this is. I don't know what it is either. And I don't find that you're and you are communicating with each other so that we can come up here and save time so that the hearing on the merits can be held and not antics like I'm performing on why is someone up here surprised? And there should be no surprises up here. There should be nothing about ambush of information. Get it done. You got 1 week, all right, and get this man's constitutional rights dealt with, but inform each other. This is not just an open door to go, we're going to do a bond hearing. There is no limit to that. What do you have to say?
Respectfully, Your Honor, again, this particular motion was brought up to the court when Mr. Power was first taking over this case.
Or are you denying that?
I did not just.
See,
Didn't come over to
see,
talk.
this is not what I like to hear between professionals. Work this thing out. You got 1 week. You're going to get this man back up here on Wednesday. Can we do it on Wednesday?
Yes, sir.
Wednesday morning. Y'all be ready.
Yes,
So we can move through this. Does everybody understand?
yes.
Sorry for the delay, sir. All right. Don't communicate. You're in the business of communicating. Thank you. Okay. It's only constitutional rights at issue. This is important. All right. Who's up?
The classic waiting game. Everyone's looking for records, subpoenas, and documents. But hold on. What happens when a case is delayed for missing paperwork? In the legal world, it's a race against time to keep things moving forward. And let's be real, if it wasn't for these delays, we'd all be out of jobs.